Hi, everyone, and welcome to our show. Welcome, Noah Kadish.
Thank you for having me.
So, I found you. I'm so happy. I'm so happy you're here. You basically specialize. Noah is a lawyer that specializes in employment and disability. Why don't you explain?
Sure, of course.
That's
so we specialize in employment and disability law.
Okay.
So they're two distinct areas, and they obviously overlap quite a bit sometimes. And
They're very different.
They're very different, but when someone has an issue in the one, very often it relates to an issue in the other.
Fair enough.
And so to break it down into effectively three categories, what we do very often in employment, representing employees who have been terminated or let go from their employers. So this can happen in a number of different ways and a number of different reasons. So someone could be let go by their employer with alleging cause for termination.
Okay.
And that's what the most severe of cases, and it's the equivalent, they say, of the death sentence, right?
Sure.
So it is if someone were to be found, for example, stealing from their company, and the company's allowed to let the person go and say, that's cause for termination. We don't have to pay you. You're out the door the same day. And it can manifest in a number of different ways. And sometimes it's warnings for performance. They say you're not hitting your sales numbers. You gotta, they'll give a couple letters and then they'll say.
So let me ask you something. If somebody got, was let go because they were caught stealing.
Yep.
Why would they come to a lawyer?
So,
Like, you know what I mean? Like, I just don't understand.
So most of the time, it's not quite so clear-cut.
Okay.
If someone was actually caught stealing, it's probably not the kind of person that goes forward with a claim. Now, what I can tell you is we deal with hundreds of people a year, and we see a range of issues. So, for example, a case that I remember quite well is an individual who worked for a prominent financial institution, and they were signing on behalf of a parent who, they took care of, and they actually, had the authority to act on their behalf in a number of different ways. They weren't allowed to sign the document. So even though they had the parents' ongoing authority to take money in and out of their account, the question becomes, did that financial institution maintain faith in that individual now to act in a reliable and honest manner? So, even though there was no hard feelings between that person and their parent, does that lead to cause for termination? And very often it's these, situations which are not clear-cut,
Gotcha.
which lead to cause. Another very recent example, there was a truck driver who is, going on his route, and you've seen these wooden pallets that they pick up items on, and the company, they have their own ones. Occasionally, the person will take pallets from dump yards and wherever else, and they made a little side business selling these. That was a more interesting question. It's, a bit of a gray area. He didn't steal from the company; they didn't lose. But was he allowed to use his company time? And these are questions.
That's interesting. You have an interesting job.
Every case is very different. Yeah.
Very interesting.
Yeah.
Okay, and the other area?
So there's cause for termination.
Okay.
So someone will come through the door and they'll say, they said, I did something wrong. Is that cause? And that's one of the issues we deal with. Another issue, which is very common, is someone's been working somewhere, whether it's for 2 months, for 40 years, and the company says, look, we have to let you go. We're not saying it's your fault. We have to let you go for business reasons,
Right.
for personal, whatever it is.
Okay.
And they're not alleging cause for termination. They give them a severance package, and the person wants to know, is that what I'm entitled to?
Can you get more?
Can I get more? Exactly. And I can tell you the vast majority of the time, the answer is yes, you can get more.
Oh, okay.
Now, why is that? Well, it's not a simple set of laws in Canada that govern this. So there's a
lot
piece
of gray areas?
And there's a legislation. So if you're provincially regulated, most companies in Canada, then the statute that governs your employment is the Employment Standards Act.
Right.
If you're federally regulated, like for a bank, it's the Labor Code of Canada. And what these two pieces of legislation do is they set out the bare minimum. So if I had to fire my assistant and I wanted to let her go, I couldn't offer her less than this legislation tells me to. Even if she signed on that contract and said, I'll accept less, it's not enforceable.
Yeah.
So that's the minimum.
Because the law is above anything else. Yeah.
Now there's another area, the common law. And in Ontario, you can think about it as what would a judge give me? So the Employment Standards Act might say you've been there for 4 years, just over 4 years, you're going to get 4 weeks of pay. And
a week for every year.
a week for every year. That's what people often hear, and they think, oh, that's what, or they hear rules of thumb that are incorrect.
But it's not.
They very often say, well, if they give me 2 letters, they can fire me without anything. Or if they give me 2 weeks per year or a week per year. And there's no hard and fast rule. So the common law is what a judge would give me. And there's over 150 factors that come into play to determine what each person would get. And the court system tries its best to give a like outcome for a like case. They want it to be somewhat predictable, but there's so many factors that go into it. So for example, the age of the employee, the length of service, how senior was their role, and primarily what these different factors are looking at is how long would it reasonably take for that person to find another job.
Another job, yeah.
So
if he's 25 or if he's 65 or 64, it makes a big difference.
That's right. So very often someone will come to me and, there are 2 employees that have been somewhere for the same period of time, and the one's offered, twice what the other one's offered. And sometimes that's right.
Yeah.
But so the companies understand that there's a statutory minimum, and then there's a big gray area. And typically, when you're letting someone go, the company doesn't, out of the goodness of its heart, give you the most you can possibly get. So very often, the person will come to us and they said, look, they said this is what I'm entitled to, and they reference a statute, and they Google it online, and they say, well, I Googled it. Google's like a lawyer, and that's what it says I'm entitled to. So that's probably, they're right? So I should just accept it. And the single biggest piece of advice I can give to anyone, when you've been fired, it feels like a blow every time.
Sure.
And very often you think, I got to protect myself, I have to get some pay, so they'll sign the release.
Get an advice before you sign, correct?
Exactly.
Get a lawyer's advice. Call Noah before you sign anything.
So
I agree.
You have a right to have a lawyer review whatever it is. So even if you think this is a great deal, they're offering me exactly what it says I'm supposed to get, you're allowed to have a lawyer review that contract and tell you. Sure. And sometimes I have to tell someone, look, that's exactly what you're going to get. That's more than you'd get. You should jump on it. Most of the time, you're going to get more than what they're offering you, because like anyone in business, you try to give as little as you can.
So let me ask you something. So, a person comes to you that they were let go after 17 years of employment, and I guess they give them a 1 week for every year of the 17 years. They give them 17 weeks, and they come to your office. The question is, are they looking for a long battle? Are they looking for a long fight to get it? I mean, how much would it cost them? I mean, the lawyer costs money.
Yeah, lawyers aren't cheap.
Yeah. So the question is sometimes, will it cost them more to fight, going through a lawyer than what they would, do you know what I'm saying?
I know exactly
at the end of the day, is it worth it?
And we hear horror stories about people that hire a lawyer and you pay them $10,000 and they win the case and you get $8,000 extra. Well, you're coming up behind.
Exactly.
So what we do is we're one of the very few employment firms that operate on a contingency fee basis. Okay. Meaning, how are we paid? Right? Most people that come to us, they say, I've just lost my job. I have no income coming in, and I don't know how to support my family. Exactly. I can't afford to pay you a retainer and move ahead from there. Exactly. So what we do is we tell them, we're going to fund the cost of the litigation moving forward, the expenses. Don't pay us now. And furthermore, you're only going to pay us if we get you more than they're offering right now. So the way we, specifically our firm, works is that we charge a percentage of the new money that we get for you.
Oh, excellent.
Right? So very simply, if you are offered $50,000, and you end up getting $100,000, the percentage applies only to that new 50, not to the initial offer. And that way, we bear the risk. And if we don't think we can help someone and get them a substantial increase, then we'll tell them that.
That's wonderful, because I think that's a concern for a lot of people.
Yeah, absolutely.
When you're right, they got fired, they have not necessarily, a lot of money in the bank waiting to pay a lawyer. That's wonderful.
Absolutely. And the other thing it does is it provides a level of power, frankly, over the situation. Yeah. When we deal with all the big retailers, the banks, any company you can think of, as long as they're not unionized. And very often they'll think to themselves, well, we're a multi-billion-dollar company. We can outlast this person. How much can they afford to pay their lawyer? Yeah. Can they spend $200,000 on a trial? Probably not. So if we wait long enough and we put them through enough effort, they're going to back away and they're going to fold.
Unfortunately, that's what happens in many cases.
That's very often what happens. So with us, they understand that we don't work by the hour. Our clients are not paying us if we have to go to 3 additional steps. They're not going to pay us more for it. they're going to wait, and we're going to perform and make sure that they don't have to, give in if they're being offered less than they're really entitled to.
Okay, before we go into disability, can you tell our viewer what should they do if they get fired or let go, or maybe a little bit before that they're feeling that the seat is hot and something is coming. They got two pink slips, or something.
Yeah.
What's your advice?
So, once you are fired, first thing you should do is obviously call a lawyer, right?
Oh, no.
And there are lawyers that will say, pay me $500 just to sit down. So we offer free consultation, so it shouldn't become a barrier to looking at what your rights are and what your options are. Now, along the way, if an employer, and there is an employer side of this, so I'll go into that after, if the employer is providing you with letters saying you're not, performing adequately, it's a warning letter, you may face termination after, it's certainly worth looking into and speaking to somebody, because what you may want to do is to, if you receive, for example, a performance improvement plan, and they say you've made this mistake and that mistake, and so, we're going to let you go if that happens again. Well, if you don't provide your reply after the fact when we're battling for your severance pay and we're saying, it was a wrongful termination, those mistakes are not cause for termination. Well, now it's your word versus their word, and who's to say that they weren't right at the time? And we have to go backwards in time and, generate that.
So as soon as they get that first
it's worth speaking
pink slip, go speak to them, right?
So sometimes even a simple reply, an email, a very polite one, saying, here's why that warning letter is, misdirected. This area is not my responsibility. Somebody specifically asked me to take charge of it for the day, and that's why. So giving an explanation, and what happens is in Ontario, it's a very high bar to allege cause for termination. So companies have a very difficult time saying that conduct was so egregious that we get to let them go and kick them right out the door.
See, I think most people don't know that.
No, absolutely. And people have all kinds of misconceptions. And they hear, right, they say you're 3 strikes and you're out. Or,
that's what I knew. Is it not true?
And it's absolutely not true.
Oh, wow.
So the example I give,
if
the conduct itself does not warrant a termination, your employer can give you 50 letters saying, we saw you chewing gum on premises. Well, even if you got 10 letters, that may not amount to cause for termination. Something else like insubordination, right? If you're yelling at your manager and swearing, or if you assault someone in the workplace, well, there are cases where they don't have to give you a single letter, they can kick you right out the door. Now, that's not always the case, but it's pretty nuanced and it's worth.
Let me ask you something. Is it not, I'm going to take the employer side of it.
Yeah.
Is it not, if I have a business and for whatever reason, I'm not happy with that employee, sorry. I'm not happy with him. I don't want him in my premises.
Yeah.
Can I not let him go? At the end of the day, it's just money, right? But you can still let him go?
So it's one of a few ways. Very often you can let the person go.
You can.
So first of all, we're talking non-unionized because they have their own collective bargaining agreements. In a non-unionized work environment, and assuming it's provincially regulated, because there's a recent Supreme Court of Canada case talking about federal employees that may change this, but for most employers in Ontario, you're allowed to let somebody go. The idea is if they haven't done something that leads you to require them to leave the premises. So if I find out my assistant, right, we work in a law firm, so it's a lot of sensitive information, people's livelihoods are at stake. If I found out that someone was untrustworthy, I may have to let them go. Now, if it's not that issue, then what the courts have said, and what our legislators, our politicians, they've come up with legislation that says, look, if they haven't done something like that, what we'd like you to do is to give them an opportunity to find another job. So people aren't out on the street collecting welfare. And so if I were to fire my assistant, maybe I would say, look, you've been good. We simply don't need you here anymore. So take the next 4 weeks and look for another job. And the purpose for this notice period is really to allow somebody to bridge that gap. Now, it's my prerogative as an employer if I'd like to have them work during that time and earn the income, or to say, we don't want the company morale affected, sensitive information. You can go home, we're going to pay you what you would have earned. So that's your notice period. And the legislation sets out that you have a certain notice period, about a week per completed year to a maximum of 8 weeks, if you're a smaller employer. If you've been somewhere for more than 5 years as an employee, and the company's large, so they have over $2.5 million payroll, then the courts and the government has said, look, we want you to have a bigger obligation. You can afford it, so we want another week per year to a max of 26.
Oh.
So that for provincial employees is the statutory minimum.
Oh.
And that's often what people are offered, or a little bit more, and they come to us and we say, hold on, there's this whole other area, there's a common law. And that's very often what we're dealing with.
Oh my God, you really have to go to a lawyer because
it gets complicated.
It gets complicated, you know. But I really would advise you that if you're not sure, just to call Noah and find out. I mean, that's my advice. That's what I did. Not for me, but that's what I did.
And we bring you in for a free consultation. And what we do more than anything is we arm you with the facts and give you what your options would be moving forwards. And at the end of that conversation, you'll have a much better idea of what your rights are, what you're either accepting or could fight for, and you can then make a decision. And on the employer side of things, equally so, if you were to want to let go an employee, you may choose to do that in a number of different ways. You might allege cause, you might choose to give warning letters, but the moment an employer, because it's such a high bar, the moment an employer is considering terminating an employee, their best advice is to speak to a lawyer immediately.
I have one more question before we move on.
Sure.
So if I'm an employee and I'm not happy and I want to quit, do I lose all my rights because I quit?
So if you resign outright, and there's no quit, resign, whatever it is, then technically you have no entitlement to a severance package. And again, the reason is the notice period, the severance, is supposed to compensate you for that lack of notice to find another job. So if you quit for no reason, then you don't get a severance package, unless it's agreed to otherwise. Now, there's a separate area of employment law that's named constructive dismissal. And the idea is you weren't technically fired, but the employer has breached a fundamental term of your employment. So, for example, if your salary...
made your life a living hell.
That's one of the...
And you had to quit.
So, I mean, the simplest example is if you earn $50,000 a year and they say you now earn 30. Well, you're not required to accept that. What if they said you earn 0? They're not firing you. Well, it's a constructive dismissal. Very often we come across instances of abuse, harassment, sexual harassment, those kinds of things, depending on what's been going on in the workplace. You may not be required to sit and, if... But
I would still suggest, if you're going through, anybody who's listening, and if you're going through those, awful thing at the workplace, before you quit, before you resign, call a lawyer. Call
Absolutely.
Noah, right?
And, I mean,
at least they'll tell you how to do it and how to protect yourself.
There are circumstances where you're required, for example, to tell the employer, they say, you no longer work in Toronto, you work in Mississauga, or, in Alberta. And there are circumstances where you'd be required to attempt it and to see if it works or not. So speaking to a lawyer beforehand will let you know whether or not you can quit and claim constructive dismissal, if you're required to give it a try, and kind of what the circumstances permit.
I'm going to tell you that no matter what, whatever situation you're going through, we don't know that. And just to Google it doesn't really. Google is not always right.
It's too complicated because there's 3 right answers. And it depends on the specifics.
I mean, call a lawyer. Call Noah. I keep telling call Noah because I have the experience. You were great when whatever we needed you for, you were wonderful.
Appreciate it.
So we don't have a lot of time, so let's talk a little bit about disability, your other area.
So the other area of focus is disability law, and we represent individuals who have had disability claims denied. So the most common circumstance that we deal with is someone suffering from a mental health issue, so depression, anxiety, one of those kinds of issues, or chronic pain, fibromyalgia, and they're unable to work. They may choose to claim disability benefits through their insurance company and explain, the doctor says I can't work anymore, I need my salary coming in, and that's when they make a claim. Unfortunately, people suffering from, intangible illnesses like mental health, like fibromyalgia, the fact is you can't find that on a CT or an MRI, right? It doesn't show up as an objective result. So we find that they have a higher tendency to have their claims denied.
Really?
So those individuals, we recommend they, come in, and same thing, we give them a free consultation. We'll go through the steps and explain what their options are. And it may be an appeal, it may be bringing a claim for your benefits. Most importantly, though, there are timelines in place. So it's important you speak to somebody sooner than later.
Right.
And frankly, very often we speak to somebody. This week I spoke to somebody and, she may have waited too long simply because.
How long is too long?
Like most of everything
90
in
days?
law, everything depends on the circumstance. So there's.
So how would they know? Like as soon as it happens?
Call someone as soon as it happens.
As soon as it happens, exactly.
So
Okay.
typically, most lawsuits in Canada, you have 2 years from the time the issue arose.
Okay.
So that's your limitation period. Now, that will not necessarily be the same in every case. There's
Right.
contracts that make it
Right.
earlier,
Right.
and so it is important to look
Call
into
right
it
away.
quickly, though.
Okay. What other? So what other beside that you know of that claims were denied?
So,
Well, not claim. Like they didn't even want to offer insurance.
yeah, there's all kinds. I mean, there's another policy entirely called critical illness. So if something severe were to happen, it's a one-time payment, very often denied. But
Really?
Yeah, you'd be surprised, and it's an objective issue.
I mean, they
but-
push this insurance so much. Like
That's
I hear,
right, yeah.
really.
And I mean, if you're suffering from depression or anxiety, very often your instinct is to say, I can't deal with, what's going on in my life. That's why your doctor's telling you shouldn't be working.
Right.
And so to deal with an insurance company who's calling you sometimes every day, that can be overwhelming.
Yes.
And a lot of people, unfortunately, just say, I can't deal with this. I'm going to walk away. So what we do is,
And the insurance company are very happy with those people.
So I can't speak to that.
Oh, I can. You don't.
But so we recommend you come in and worst case scenario, let somebody help you. Once a lawsuit has begun, the defendant is not meant to contact the person directly. They speak to your lawyer. So we're told that one of the biggest things that we do for our clients suffering from mental health issues is take over that burden and lift a weight off their shoulders so they don't have to deal with that issue.
So let's say a claim started, long disability. What would make them stop it? Like the insurance stop it?
The 3 most common times for a denial of disability benefits is on the application for short-term, on the transition to long-term, and after usually 2 years. Now, the reasons are varied. Most commonly, they'll say it's insufficient medical evidence. They'll say, well, your doctors say you have depression and anxiety, but we don't think it's so severe that you can't work. So that's the most common reason for the dispute. And that will happen on the application for the first part, for the second part. And there's a misconception. A lot of people believe that they only have long-term disability benefits for 2 years. And they don't understand their policy provides usually 90-something% of policies provide benefits till age 65.
65, yeah.
But what happens is after 2 years is a change for most people, a change in their test for benefits, for eligibility, from an inability to do the essential tasks of your own job to an inability to perform the essential tasks of any job.
I got you.
So
after 2 years, they want you to basically go and try to do something else.
Yes, and whether or not there's a position available is not relevant. It's whether or not you're capable of performing it.
Right.
So to give you an example, if someone were, a mover, so they carry heavy barrels, and I've dealt with a case specifically like this, they're moving heavy barrels all day, and they tear the rotator cuff, they obviously can't continue to work in that job. So for the first 2 years, they may be eligible for benefits. After 2 years, the test isn't whether they can do that, but whether they could do any job that they're suited for by way of education, training, or experience.
Right.
And so the company might say, look, we think you can go work as a secretary, or to work, as an administrative assistant, work in a toll booth, whatever that job is.
They don't care if they can find a job or not. They just
the availability of work is not relevant. The test is whether or not you could perform that.
Gotcha.
And that test will be paired to your previous income. So usually it's around 60% of what you used to earn. So for example, they couldn't tell the CEO of a company, go work as a janitor, because they're probably not going to be able to earn 60% of what they used to. They would have to prove that that CEO would be capable of doing tasks that would earn 60% of the previous income. So it's usually a higher level kind of position.
Wow. Well, I've learned a lot today, and it's not enough. You have to come back. Like there's no.
Thank you.
And if anybody has any, if anybody's watching and they have questions and they want Noah to come back, please write us, let us know, and we'll definitely have you back because our time is up. Can you believe it?
Flew by.
Thank you so much. Thank you so much for everything, and thank you for all this information. And wow, I've learned a lot. I appreciate it.
Thank you.
I would say, really, thank you for joining us today, and we'll see you next week.